The only people who don't want to disclose the truth are people with something to hide.
We are live on Sunday, February 10th, and we are talking with Richard B. Sanders, a former justice of the Washington State Supreme Court. His website is www.justicesanders.com. We are talking right now about the case of Linda Jordan. She is a Seattle housewife who tried to challenge the eligibility of Barack Obama to be on the ballot as a candidate for president in the most recent election, the 2012 election. And she filed some challenge to that in August of 2012, and her case was dismissed, which is not too unusual with these kinds of cases. But what is unusual is that she was sanctioned by the court, and she was sanctioned $13,000. And as Judge Sanders has just told us, he has done some research on this, and he has found that the Attorney General actually billed the Secretary of State about $4,000, not $13,000. And Judge Sanders is representing Linda Jordan in trying to get this sanction reduced or eliminated. Judge, I wanted to ask you about this. I want to ask you one more question. I'm going to beat this dead horse of the frivolousness one last time, and then we'll move on. I noticed that Linda Jordan claimed that there are cases that challenge eligibility of office holders and candidates all the time based on residency requirements and whether or not they meet the age requirement or some qualification like a judge. It has to be an attorney and so forth. So it's not unusual to challenge a candidate's eligibility, but was her argument just off, or was the court just in no mood, or what happened?
Well, this has been tried before to bring an action to disqualify Barack Obama from the ballot, and the Attorney General pointed to a case, I think it was back east someplace, where the plaintiff was $20,000. So there was some precedent to dismiss this as frivolous, and I think that you're probably right. She's probably right that had she been attempting to challenge some other candidate on a more limited ground of residency or of age or of where they were actually located, she may have lost her case, but there wouldn't have been this award. But it's sort of a red flag, I think, to the establishment when you bring an argument like this, because if she or someone in her position were to actually prevail, this would really upset the apple cart, and the system just can't countenance that.
How was this sanction imposed? In other words, as I understand it, there was a case in Thurston County Superior Court before Judge McPhee, and is he the one who imposed the sanction the first time?
No, he wasn't.
Okay.
He just simply dismissed the case. She appealed to the state Supreme Court. The state Supreme Court dismissed the case as frivolous, and then asked the clerk of the court to calculate a reasonable attorney fee, and which the clerk did. And now we are appealing that calculation back to a panel of the court, and that's what I've been hired to do.
I see. So the state Supreme Court, and I understand it's actually 5 of the 9 justices imposed the sanction. Is that right?
Yes, that's correct.
And so the whole.
Let's put it this way.
Go ahead.
5 of the 9 justices said that she would be required to pay the Attorney General's reasonable attorney fees. Right?
Okay.
They didn't actually calculate the amount. They had the clerk do that. And we brought a motion to modify the clerk's ruling, which goes back to judges on the court.
Okay, so I'm glad you clarified that. So these 5 judges said this is frivolous. She has to, loser pays in this case. The $13,000 figure was calculated by the clerk of the court.
That's right. And it was calculated based upon a request by the Attorney General. The Attorney General said that this is a reasonable fee. The Attorney General said that the Secretary of State deserves to be reimbursed his attorney fees. What the Attorney General did not say was that the Secretary of State was actually billed that amount, nor did the Attorney General say the Secretary of State actually paid that amount. And as it turns out, it was about it was about $4,000, a third of it. And I think that attorney generals, public lawyers, should have the responsibility to be forthright with the court. If they want to get more fees than they actually charged their client, they should at least disclose to the court what they actually charged their client, and then make an argument that they deserve more for some reason. But that's not what happened here.
So the $4,000 figure, that was some sort of accounting entry between one State Department and another State Department, and it's documented somewhere. Where did the $13,000 figure come from?
The Assistant Attorney General said that he had about 50 hours into the case, and a reasonable hourly rate is $250 an hour. And you multiply the two, and you come up with $13,000.
The billable hours.
In real life, what the Secretary of State was being charged was $65 an hour, not $250 an hour.
Okay. Now you have filed a motion to have this reheard. What exactly have you done?
I filed a motion setting forth the true facts of the case, including what the Attorney General actually charged. I made a legal argument that the correct way to calculate a fee is first the actual charges, and then you can adjust them down if they're unreasonable, or if they're duplicative, or if there's too many hours involved. And then I argued that it doesn't take 50 hours to dismiss a frivolous case. It takes a few hours, but nothing like 50 hours. So I thought it was an unreasonable hourly rate in terms of what was actually charged, and I thought it was an unreasonable amount of time to accomplish the result. So believe me, if the shoe were on the other foot and the private citizen were getting an award of fees against the government, the Attorney General would be all over the private citizen if he found out that the lawyer was asking more in fees than was actually charged to the private citizen, or if the lawyer was seeking compensation for time that was not really necessary to produce the result. So, there should be a single standard here, not a double standard, one for the private citizen and the other for the government.
Exactly. So what happens now? You have filed this motion, and is there going to be an actual hearing or what?
Well, the Attorney General can respond in writing, and then I can reply in writing, and then the clerk will determine on her own whether or not she wants to modify her award. If she doesn't want to modify it, then it will be sent to a department of the court, and they will consider this on the briefs that are submitted. So there won't be a face-to-face oral hearing, but it will be paperwork.
Right, there'll be some paperwork going back and forth. And do all 9 of the justices vote on this?
Well, it'll go to the court's divided into 2 panels of 5. The Chief Justice sits on both of them. And if the panel is unanimous, then that will end it. If they're not unanimous, then it will be heard by all 9 justices.
I see. So they're split. Then you get to argue it. That's interesting. And the 5 who ruled that she should be sanctioned, they were unanimous, were they?
Yes, they were. Yes.
Okay. So very interesting. We will continue our conversation about this, and also Judge Sanders, I'll ask you some other general questions about being a judge and so forth, and your opinions about unpublished opinions. We are talking with Richard B. Sanders. He is former Justice of the Washington State Supreme Court. His website is www.justicesanders.com. By the way, we've been talking about the case of Linda Jordan. She actually has in case she has to pay this $13,000 sanction, she has a legal defense fund. You can find out about it by going to www.obamaforgeries.com.
The only people who don't want to disclose the truth are people with something to hide.